Good morning, everyone. I'm Greg Katsas from the D.C. Circuit and formerly of the White House Counsel's Office. Deregulation was obviously an important matter when I was in the counsel's office. As Naomi's explained, it's still a critically important matter for this president. We have a very distinguished panel to address this. So I'll just introduce them briefly and let them get going. Our first speaker will be Professor Philip Hamburger. He is the Maurice and Hilda Friedman Professor of Law at Columbia Law School and also the president of the newly formed New Civil Liberties Alliance. Professor Hamburger is a leading scholar in constitutional law, and he's published in areas such as administrative power, judicial review, and religious liberty. Of particular interest, in 2014, he published a book provocatively titled, "Is Administrative Law Unlawful?" He argued that it was, and his book was cited favorably and extensively by Justice Thomas in his separate concurrence in the American Railroads case. He previously served as a law professor or a visiting professor at the University of Chicago, George Washington, University of Connecticut, UVA, and Northwestern. Professor Jonathan Turley is the J.B. and Maurice C. Shapiro Professor of Public Interest Law at the George Washington University Law School. He's published dozens of academic pieces. He's often on TV addressing legal issues of the day. He frequently testifies before Congress, and he maintains an active litigation docket, which includes his recent successful representation of the House of Representatives in House v. Burwell, which invalidated the cost-sharing reduction payments made by the Obama administration under the Affordable Care Act, a case that I might have read once or twice in my prior job. In a recent study, he was found to be the second most cited law professor in the country. Who beat you out, by the way? The Honorable Neil Eggleston is a litigation partner in the Washington office of Kirkland and Ellis. His long record of public service includes 2 stints in the White House counsel's office, first as an associate counsel under President Clinton, and more recently as the last White House counsel to President Obama from 2014 to 2017. He's also served as deputy chief counsel for a House Select Committee handling the Iran-Contra investigation and as chief of appeals for the U.S. Attorney's Office for the Southern District of New York. He served as a law clerk to Chief Justice Warren Burger, and he's taught at the Harvard and Yale law schools. And finally, last but not least, Todd Gaziano was just named director of the newly created Center for the Separation of Powers at the Pacific Legal Foundation. Since 2014, Todd has also served as PLF's Chief of Legal Policy and Strategic Research. He began his career as a clerk to Edith Jones on the Fifth Circuit. He worked in the Office of Legal Counsel at the Justice Department and as Chief Subcommittee Counsel for the House of Representatives. Also was a founding director of the Heritage Foundation Legal Center. To get things going, I will note that the conference materials describe Todd's separation of powers group as one that, this is in their words, works to restore the structural protections of liberty in the Constitution and seeks to end the unconstitutional administrative state. With that, turn the floor over to Professor Hamburger.
Well, I have 3 points this morning about the need for structural change, about the new Civil Liberties Alliance, and about the administrative threat to civil liberties. First, we need structural change. During the past century, the administrative state has transformed American government. We still, of course, have the shell of a republic, but there's grown up within it a very different sort of government, an administrative state within the Constitution's United States. We're therefore fortunate that we live at a time when many Americans recognize the danger, but there has been remarkably little structural change, except perhaps outside OIRA. To be sure, there has been some regulatory reform, and this is to be applauded, but there's been little of the enduring, deep reform that we need. As a result, even the regulatory rollback is vulnerable. A new president could reverse it in minutes. We may take years to get that rollback. It will be reversed in minutes. Though it is deeply gratifying to have my friend Naomi Rao at OIRA, the institutions that could make long-term structural changes have failed us. Congress has sat on its hands. It has not reclaimed its legislative power. It has not ended judicial bias by abolishing Chevron or other deference. At best, it uses the Congressional Review Act, which functionally establishes a legislative veto on executive lawmaking, the very reverse of the Constitution system. The judiciary has yet to do much, if anything. It is good to have Justice Gorsuch join the Supreme Court, but after more than a century of administrative power, will a majority of the court have the strength of mind to repudiate it, even a fraction of it? Perhaps, but only if we press them repeatedly to do their duty. The executive speaks a good game against administrative power, a very good game, but has yet to introduce structural changes. The Justice Department guidance memos are admirable, but even these were not based on constitutional principles. They were not directly applied to other departments, and they were not framed as rules, let alone as a declaration by the Attorney General that, as in his opinion, they were contrary to the Constitution. There's much that the executive could do structurally, but 2 years have passed with little action, and I confess I'm not surprised. Real change, long-term structural change, will not come from above. It must come from below, from us and the many millions of Americans who share our discontent with unconstitutional government. Each of us must feel a personal responsibility to protect the United States from the administrative state. Each of us must seize the day. We cannot rely on anyone else to do it. And this leads to my second point concerning the new Civil Liberties Alliance. I began my discontent with the administrative state perhaps as a tax lawyer many, many decades ago, but more directly in 2014 by publishing Is Administrative Law Unlawful? But writing was not enough. I realized that sometimes one has to actually stand up and do something. For I realized that there was no national litigation group entirely devoted to dismantling administrative power. There was no group, all of whose litigators specialized in this subject. In fact, most litigation groups were merely fighting overregulation, and I think many people who are affected by overregulation still think of it in those mild terms. That is, they were not engaged in strategic litigation to defeat the types of unlawful power that cut across different areas of regulation. They might fight regulation of coal or the FDA, but they would not fight deference as a whole and try to bring it down in a systematic, strategic way. I therefore established the New Civil Liberties Alliance, a civil rights group that engages in pro bono litigation against administrative power. The NCLA is unique, for it is entirely devoted to the administrative threat. It will be litigating in both federal and state jurisdictions. It will file amicus briefs, but it will also work from the ground up in trials. It is called an alliance quite deliberately because it aims for cooperation amongst litigation groups. And above all, it envisions the fight as a civil liberties movement, a civil rights movement on behalf of all Americans, not business, not the regulated, but everybody. And by the way, in front of this crowd, I should add, although we've already done much hiring, we're continuing to hire experienced litigators, and we pay competitive public interest salaries. Okay, third and last, I want to lay out the NCLA's vision of administrative power as a threat to civil liberties. For more than a century, administrative power has been understood as a threat to business, as a threat to separation of powers, as a threat to federalism. All of this is true enough, but it's not going to move the mass of Americans. And the NCLA recognizes that administrative power is also a threat to civil liberties, and it must be fought in a civil liberties movement. What do I mean by this? Administrative power, I think, is the greatest threat to civil liberties in our era. No single development in our legal system deprives more Americans of more constitutional rights. Traditionally, the most systematic threats to civil liberties came in attacks on particular groups, and this remains a problem. But increasingly, there are also broader threats that affect the civil liberties of all Americans, and administrative power is the primary example of this broad sort of danger. You can read the details in a little red book that I see is circulating here. For now, I'll just summarize a few of the points. First, due process. In defense of administrative adjudication, it is said that due process is essentially a limit on the courts, not on the other parts of government. It is also said that administrative adjudication provides all the process that is due. In other words, that lesser amount of process where the due process clause doesn't so centrally apply. But guarantees of due process of law develop precisely to bar any binding adjudication outside the courts. As put by St. George Tucker, lecturing on the Bill of Rights in the 1790s, due process of law must be had before a judicial court or a judicial magistrate, a point echoed by Chancellor Kent, Joseph Story, etc. Nonetheless, the government nowadays imposes fines and other penalties in administrative proceedings in violation of due process of law. A second example of the violation of civil liberties. Administrative adjudication violates jury rights. Juries are available only in the courts. And the right to a jury in both civil and criminal cases thus precludes binding adjudication in other tribunals. The only exceptions are admiralty and equity. But nowadays, the Supreme Court strangely says that the government's public rights defeat the merely private constitutional right to a jury. Your constitutional right has been designated as private because it comes from you vis-a-vis the public right of the government that defeats it. Third, and getting increasingly serious, there are judicial violations of procedural rights. There are some judges in the room. Listen up. The loss of juries and due process and administrative tribunals isn't the end of the matter because the losses persist in the courts. Judicial deference to agency interpretation, for example, violates the judicial duty of independent judgment. And where the government is a party to a case, this deference is institutionalized judicial bias in favor of one party's legal position in violation of the due process of law. For decades, there have been thousands of law review articles on Chevron as a separation of powers problem. That misses the main point. What matters is what happens in court. And when you get to court and the government's a party, it's judicial bias. And by the way, the same too for all the deference doctrines, including deference to administrative findings of fact. The overall result is a double violation of rights, initially by the agencies and then compounded by the agencies themselves. I want to close with a fourth administrative threat to civil liberties concerning equal voting rights. Most of us don't think of administrative law in terms of equal voting rights, but it's actually the central point. Federal administrative power arose precisely to counteract the effects of equal suffrage. The two preeminent developments in the federal government since the Civil War have been equal voting rights and the administrative state. And this isn't a coincidence. Administrative power expanded in the wake of equal suffrage because popular participation in representative politics prompted a shift of legislative power out of Congress and into administrative agencies. Early progressives were actually remarkably candid about this. They then learned to shut up and change their tune. But they were amazingly candid. Woodrow Wilson, particularly so, of course. He couldn't help himself. He was an academic. He said that the reformers bewildered, and remember, these are his words, not mine. The reformers bewildered by the need to persuade a voting majority of several million. And of course, he especially worried about the diversity of the nation, which meant the reformer, and I quote, needed to influence the mind not of Americans of the older stocks only, but also of Irishmen, of Germans, and of Negroes. You get the point. I could go on and on quoting this stuff, but you get the idea. Rather than try to persuade such persons, Wilson welcomes administrative governance. The people can still have their republic, but much legislative power would be shifted out of an elected body into the hands of, the right sort of people. Rather than narrowly a matter of racism, this has been a problem of class. The enfranchised masses have disappointed those who think they know better. But even without Wilson's overt racism, when legislative power is removed from the representatives of a diverse people, there are implications for minorities of all sorts. The problem is the relocation of legislative power a step further away from the people and into the hands of a relatively homogenized class. Administrative power ultimately makes a mockery of the struggle for equal voting rights. It reduces equal voting rights to a sort of bait and switch. And it thereby confirms how severely administrative power threatens civil liberties. In sum, we need structural change. This is the goal of the new Civil Liberties Alliance, And it is difficult to think of a more serious civil liberties problem for the 21st century. Thank you.
Professor Turley.
Thank you very much, Judge, and thank you to the Federalist Society for inviting me to be part of this esteemed panel. I only have a few remarks, and I'm going to try to do what is normally impossible for a law professor and keep it short. The issue that I wanted to address, really sort of the primarily issue, is to question why Chevron is still here. For many years, as many of us who have been critics of Chevron, we've talked about the impossible, that someday we would actually have two houses in control of someone of a party that was against Chevron and a president willing to do something about it. And yet it's still here. It's flourishing. It's sort of like Adam Sandler's career. No matter how many bad movies there are, it continues. And movie after movie comes out. I can see we have some Adam Sandler fans in the room. You know, it's funny because when I was thinking about this, I've been up to my elbows recently in the opioid litigation, just not as a litigant, but in studying the huge amount of litigation coming out of that area. And the more I read about, the opiate crisis and the addiction, I thought, my God, this is Chevron. It's same thing. You've got all these people that say, really, I can handle this. It's not taking over my life. You've got a series of enablers allowing this to happen. And then you have the failure of any of the three branches to admit they have a problem. And so the question is, how do we get to the point where people who have professed that they don't like Chevron will do something seriously about it? Now, an example of where we are today and how disconnected we are from both the law and reality can be found in the recent digital realty case. Now, in that case, you had reporting done under whistleblower reporting done under the Dodd-Frank reporting provision. That provision states quite simply that it covers reporting violations, quote, to the commission, close quote. Just as straight as I just said it. There was no ambiguity, no other clauses really of importance. And yet, when that issue went to the D.C. Circuit, they found it was terribly ambiguous and required Chevron deference. Turns out you don't have to report to the commission. When you say to the commission, it means report to the commission and other possible entities yet to be defined. Now, this is in many ways a prototypical Chevron case. I actually can agree with the inclination of the court. I could agree with the idea that this should be broader, that the whistleblower protection should cover more. But that's not the question. The question is not whether the courts agree with the way Congress did the law. It's not a question of whether we can improve it. It's a question of what the law says. And the law said to the commission. Now, ultimately, as many of you know, this unified an otherwise divided court. We actually didn't get to use our new shiny justice, and that is Neil Gorsuch. I was hoping this would be his debutante decision, but it turns out we didn't need Gorsuch on this one. When I testified at Justice Gorsuch's confirmation, and one of the things that I emphasized at the confirmation was that not only is he an intellectual of the first order, but he very well could end the Chevron period. And when I say end the Chevron period, I'm meaning not by ruling insular cases against it. Neil Gorsuch has the ability to lay a new foundation, something that will actually replace Chevron. Now, we didn't see that in this case because it basically failed on the first prong. It wasn't ambiguous. But you have to ask yourself, why? I mean, why would you have trouble with this case? Why would it even go before the Supreme Court when you have such clarity? And the reason is because Chevron is a crutch. Chevron is an addiction. It's an easy way for courts to get out of problems, but it's also a very easy way for courts to achieve what they want to achieve with the appearance of neutrality. It is what Carl Llewellyn referred to when he did his famous Parry and Thrust scholarship on the formalist period. where he identified that there was a series of canons of construction, one that would say if A, do B, and the other saying if A, do the opposite of B. And he said the problem is you make it look neutral, but your bias is in the selection of the canon. And so it's the worst of all worlds. Chevron works in the same fashion. It seems to be there if you really just don't like the way Congress did something. To show you what parallel universe we find ourselves, you could take a look at the recent Combi litigation. The National Restaurant Association has filed for a petition of certiorari that is pending before the Supreme Court. In that case, you dealt with the issue of tipping and whether you can divide tipping, whether owners can take it and pool it, and other types of issues that I frankly don't understand. And so this goes to the Ninth Circuit, and the Ninth Circuit reads the statute and renders its decision. The Department of Labor didn't like the decision. So as we've seen in other cases, they simply enacted an interpretation that reversed a Court of Appeals of the United States. Now what's amazing is this ends up back at the Ninth Circuit, and instead of saying, wow, I thought we were an Article III court and you're not Congress, instead they reversed themselves, Combi, and upheld the rule. Now, this sort of ties into what Phil said, and I'm so happy to follow Phil. He's my former colleague, and he's 10 times smarter than I am. But this is why this is a civil liberties issue, and Phil touched on the point that I wanted to focus on in ending these remarks. Part of the problem that I've had throughout my career, I know many of us have had this problem in talking about Chevron, is the failure to recognize it as a civil liberties issue. I happen to agree with a lot of things the court does. I mean, academics tend to agree with a lot of the bureaucrats. They're a lot like us. They're dweebs with higher degrees, and they tend to study issues and come up with wonky solutions. What's not to like about that? But the problem with that system is, of course, they're not elected, neither are we. And we have a system that is based on this center of gravity that falls between the three branches. Madison actually viewed it in these gravitational terms. And I mentioned this in an earlier conference, that one of the most fascinating things as a Madisonian scholar that I encountered was his writings from college, in which he spent most of his time not really talking about Montesquieu, but he talked about the new physics and Sir Isaac Newton. And he was fascinated by this idea of the gravitational pull of large objects and how you can actually be in a locked orbit, three moving objects locked as one. That image, of course, influenced how he viewed our tripartite system. The center of gravity in that system is smack dab in the middle of those three bodies. And that center of gravity is moving. And what people don't seem to understand, particularly those people covering these stories, is this isn't about whether the business interest win or whether the labor interest win. It's about how the system works. And the framers viewed the separation of powers as a civil liberties matter. They really didn't give a whit about the inherent authority of the people in these branches. They believed that by dividing up the power and confining it, they could protect civil liberties, because the greatest danger to civil liberties is the concentration of power. They would be mortified by the system we have now, a fourth branch that is becoming a government unto itself. That's why Phil is so right. This is a civil liberties issue. And they're all at fault. Even the Supreme Court has recently expanded Chevron with Arlington versus FCC, where it crossed the Rubicon. You remember this has been a bait and switch from the beginning. When Chevron came down, we were told it's just basically a common sense approach to allow agencies to do their work without endless litigation. One of the things that those of us who were critical of that view said is, well, at least agencies can't use Chevron deference to define their own jurisdiction, because that would be ridiculous, right? That would just be facially ridiculous to allow an agency deference in defining its own jurisdiction, who would sign on to that? And the answer is the United States Supreme Court in Arlington versus FCC said, yeah, we'll just make you a perpetual motion machine of a bureaucracy and allow you to define your own jurisdiction. Now, the unfortunate thing about this particular addiction is that opiate addiction usually begins with a serious illness. Most people that develop this addiction started it with a prescribed drug and they just couldn't kick it. The terrible thing about the Chevron addiction is it didn't even start with an illness. Everything was pretty much okay under Skidmore. So Skidmore had if you go back and read Skidmore, and people don't do that anymore, when you go back and read it, you're like, wow, this is a remarkably commonsensical approach. The court said, you know what, when we look at agency determinations, we're going to give it considerable weight and respect. But we'll make the interpretation in light of what the law says. And so that was the case that Chevron essentially gutted. So my favorite thing about Neil Gorsuch was when he said in a case that he got a great deal of trouble over, the Gutierrez case, which I thought was a brilliant decision on his part, his opinion, I should say. But he asked in the question, what would happen in a world without Chevron? I know it sounds sort of like, national public TV, what would happen in a world without Chevron? Or maybe a Fox series like when sharks attack. And it's a great question. The answer? Nothing. We would be back to Skidmore. Agencies would still get deference, and the courts would get back into the business of interpreting law. But when you read accounts of the erosion that is perceived of Chevron, people speak of it as if we are going back to the Dark Ages. So I agree with Phil that we need to walk towards the light. And we need to get these people who said they were opposed to Chevron to act that way in all three branches and return this locked orbit that Madison designed. Thank you very much.
Mr. Eggleston.
Thanks very much. I really appreciate being invited. I was here last year, I think, on a different panel, and I've been here on occasion. And as I say, I appreciate the invitation every time I've been asked. So, as you might predict, I disagree with everything they say, and I knew that, and I think I'm going to disagree mostly with Tom, who's about to follow me. So I actually thought that I would talk about kind of a narrower issue and talk about the way I thought about these issues when I was White House counsel, and particularly the way I thought about the litigation that arose out of the various sort of regulatory issues that came up with us. Let me just start, though, Your Honor, on House v. Burwell. If you think you read it a lot, it came down in my era, and I read the briefs, I read everything, and I read the decision, read the briefs in the D.C. Circuit, and sort of worried about it. I will only say one thing about it, and I think Don is going to be here later. I've said almost nothing publicly about Don and my transition, and I hope he'll forgive me just this one thing, because otherwise I've never really said anything about it in deference to him and what I know is a tough job of being White House counsel. But in talking about this case with him, I said, look, you got to remember, we started with 60 senators and the House, and when we're done, we have not the House and not the Senate. And so as you think about whether or not it's a good idea to have one House have the ability to have standing, you should think to yourself that you currently, have Mitch McConnell and Paul Ryan. Well, we started with Nancy Pelosi and Harry Reid. And so just think through whether this is really a great idea or not. Obviously, I'm not sure, actually somewhat, and I'm not going to ask you, Judge, but somewhat lost track. I know there's been some activity in the D.C. Circuit about it, but somewhat lost track of where that actually stands. So I really want to talk about a couple things. I want to talk a little bit about the current legal landscape. I was struck by what the administrator said about guidance, and I would just want to say a word or two about that, because that's another issue I thought a fair amount about. And the last thing I want to talk about, just very briefly, is this issue of nationwide injunctions, which is bedeviling this administration in the same way that it very much bedeviled my administration. meaning President Obama's administration, not mine. And so those are the three issues that I want to touch on briefly. You know, I had my share of wins as White House counsel in regulatory matters, but I also had losses. And I recognize that the losses that the administration now is experiencing are quite painful. The losses were quite painful when we experienced them. But I've been watching some of the lawyering, and I just want to make some comments on some of it. And they relate really to the litigation over the regulatory state. Early on, the administration had a number of cabinet secretaries take the position that regulations that had gone into effect, had survived the Congressional Review Act and had gone into effect, could be delayed by the actions of the administrator. When that happened, I thought to myself, well, that's curious. I wonder how that's going to go. And as you all know, those essentially were struck down by the courts. For good reason, regulations can only be amended by new regulations. They can't be amended by the whim of an administrator. That applies whether the administrator is a Democrat or a Republican. And essentially, regulations are designed to be hard. Difficult regulations, controversial regulations require a significant amount of work or significant amount of underpinning and justification. They are always litigated in the courts. And I was surprised, frankly, that the administration took an early position that I thought had a very high likelihood of losing in the court, and it ultimately did. What I began to think the 3 years that I was in the White House counsel's office, and is that losing begets losing. There is a aura around the president of infallibility, particularly early on in administration. Unfortunately, I had the last 3 years, so I didn't have the early on patina. But there's a patina of newly elected and sort of an inevitability and a deference that takes place. And I was always careful. I did not want to litigate ones that I thought we had a high chance of losing. And frankly, there were occasions when I said to the president when he wanted to do something or other, not going to give any content to that, but when he wanted to do something, I would say, look, I think we're right as a matter of law. I think that courts should sustain what you do, and I think lots of judges, including judges that's appointed you, would not agree with what you do and would enjoin this activity. And he generally sort of set with that kind of a record, did not go forward because of the sort of issue of a perception of a president acting in a lawless fashion, and I thought that was right. So I was a little surprised that they sort of did that, and it, to me at least, had the outcome that I really pretty much predicted. The second thing, I just want to give an example, and I mentioned this when I was talking about regulations, and again, I get that there's a sort of an issue about the regulatory state, and we're going to hear more of that from Tom, I think. I'm now a practicing lawyer at Kirkland and Ellis. I have been a practicing lawyer for most of my career, and so I think about these more in terms, I think, of practical litigation issues, and frankly, I'll be on whatever side I want to be in connection with all of these. But I was struck about something that happened fairly recently, which is the EPA administrator is seeking to reduce the Obama regulation on gas mileage, and there's been a lot of attention to that that's come out recently, a lot of talk about what's going to happen with California and all that kind of stuff. The Obama administrative record is about 1,200 pages. It is filled with scientific opinion, economic opinion, discusses the various different people in support of the rule and oppose the rule. And when I saw that that Secretary Pruitt was seeking to reverse that, I thought to myself, geez, that's interesting. I wonder what the basis was for that. And the reason I did is that, again, as White House counsel, I always think to myself, and I was there, and Greg, I don't know if your office was right next to mine or sort of catty corner from mine, but you were the one right next to me? Okay, well, great, okay. So a beautiful office, by the way, for those of you who haven't been there. But I thought to myself, well, that's pretty bold. I wonder what they have done in order to create a record that's sufficient to overturn a regulation that had been put in place by, frankly, the same agency, a different administrator, but the same agency fairly recently. And so I read it. And I urge all of you to read it. It is 38 pages long. There's basically no economic analysis in it. There's no scientific analysis in it. It basically recites the complaints of the automotive industry and the difficulty that they say they will have meeting the rule. And I'm not here as a value judgment about which is right as which is wrong. I don't actually have a view about it. And just because I was in the Obama administration, I never looked at this rule. I don't have a view whether one is better than the other. But as a litigator, I was struck at the difficulty the administration has put the courts in if this is their basis for overturning what the rule was that was put in place recently. There's a line in there that says that the science has evolved since the Obama rule, but then you look at the 38 pages and struggle to figure out, well, like what has changed? And the courts are going to need a lot more than just a raw assertion of that. So I've, as I say, since I supervise so much of this from my position as White House counsel, I've continued to view and been fascinated to see about how it's been litigated in this administration as well. Let me just talk first just a minute about guidance. I was very interested. I'm glad I got here in time to see the administrator talk and respond to a question about guidance. For some reason, guidance seems to have taken on a pejorative tone. And I think AG Sessions last fall came out with some pronouncement that they were not going to issue any more guidance. I've lost track of whether that was the whole administration or just the Department of Justice. I will tell you again, as someone who spends a fair amount of time representing large companies, that one thing large companies like is certainty. They'd like to know what enforcement priorities are. They like to know how agencies are going to interpret their various different mandates. And in that sense, I think guidance is useful and helpful. And I think basically that's what the administrator said. What is not useful and helpful, and I think she also said this, and I agree with this, is that guidance should not take the place of a statute and should not take the place of a regulation and should not impose new obligations or new duties on the regulated community, because that should come up not through some informal process, but if it's going to happen, it should either happen through Congress, through a statute, which I know everybody here would agree with, or at the very least through a regulation with the enormous process that goes through it. And I was sort of heartened, actually, that the administrator seemed to think about it. I don't know if any of you agree with what I'm saying, but seemed to think about it a little bit the same way I was. So the last thing I just want to talk about is nationwide injunctions, which have gotten a lot of attention. I mean, these really, they were not unheard of before my 3 years as White House counsel, but they were pretty rare. The one that stung me most was the the Texas DAPA case, where the district judge entered a nationwide injunction and the Fifth Circuit ultimately affirmed. I always like to say that we got the same number of votes throughout, except for the district judge. The two judges who denied our stay application turned out to be the same two judges who, I don't know how this happened, but the same two judges who heard it when it came back on the merits. The dissenting judge changed, so I was 2-2 in the Fifth Circuit, and then obviously 4-4, I guess, in the Supreme Court. That was pretty painful, and we had some others. And I'm going to talk about one where where I think it was quite wrongly decided, and I'm opposed to sort of universal use or this real common use of nationwide injunctions. These tend to be, though, I think, the kinds of matters where you like nationwide injunctions when they're against the other side and you don't like them when they're against you. I mentioned DAPA. AG Sessions has been very vocal about how much he dislikes nationwide injunctions. I can tell all of you, if you Google him, he was very vocal about how great he thought the nationwide injunction was in the DAPA case. So I think it's more a principle of you hate it when you lose and you like it when you win. And I don't blame that, because I have some of the same feeling, although I think about it a little bit differently, which is if they could do it to us, they have to be able to do it to them. I think I have a little bit of sour grapes view sort of the whole thing. And I should also say my former law partner, Beth Williams, I don't know if Beth is here, I haven't seen her, but now as a senior Department of Justice attorney, gave a speech in the last month or so also sort of condemning nationwide injunctions. I think they sometimes have their role. I think actually in the DAPA case, I sort of hate to admit this, it's sort of hard to think how you would implement once you decide that once you agree with the decision or once you've accepted the decision, hard to know how you would implement that except through a nationwide injunction, because people can move among circuits. I think that would be hard. That's 2 minutes. Actually, I think also in the travel ban case, if you think about it, I know everybody disagrees here with the travel ban outcome in all those cases, but if you were to accept the travel ban outcome, then I think it's very hard to think of that not being a nationwide injunction. I don't know how you would do that sort of circuit by circuit. It doesn't really work in any other fashion. But I just want to spend a minute in giving you one that came up in my era that I thought illustrates the necessity of courts thinking about the plaintiffs that are in front of them and giving relief to the plaintiffs that are in front of them. And that is a district judge in Texas enjoined the Department of Education's transgender bathroom guidance. He had a couple of school districts in front of him, maybe a couple of states, and he issued against the guidance and enforcement by the Department of Education of the Department of Education's position on transgender bathrooms. I know this is a hot button issue. I raise it not because of the issue, but because of the nationwide injunction scope. So the judge then issued this nationwide injunction that applied to all states, all school districts, and essentially prevented the Department of Education from going forward. And in fact, the injunction applied in the Fourth Circuit that had already sustained the Department of Education's guidance. So we're in an odd position of a district judge having entered a nationwide injunction that was contrary to a position taken by a higher court, not the next higher court, but a higher court. And so as people are being critical of nationwide injunctions, I would say I'm generally of the view that we should be at a principle where the court deals with the plaintiffs in front of them and decides what could be done and whether a nationwide injunction is necessary in order to provide relief to those plaintiffs. I give you, I think, was probably the most egregious example. Thank you.
Thank you. Todd.
Thanks. I've been a proud member of the Federalist Society since almost its beginning, but I'm especially delighted to be among this distinguished panel and under the direction of Circuit Judge Greg Katsas. That Greg Katsas is a judge is itself propitious. In any event, I'm going to focus my deregulatory landscape talk on the most promising targets of opportunity to nudge the unconstitutional administrative state, and yes, it is, back toward the constitutional order. Gary Lawson coined the phrase, the rise and rise of the administrative state, to signify the seemingly unstoppable growth of the administrative state over the past 80 years. But we need to distinguish its current scope and power from its intellectual foundation. Its raw power continues to grow, but its legitimacy is increasingly undermined. A principal criticism has always existed, but it was increased significantly after the late 1970s. Jonathan Turley's been at it for quite a long time, thank you. But no one has done more than Philip Hamburger in recent years in sharpening the historical and legal critique. And there are many, many others who've added to the lengthening indictment. This coincides with increased political and judicial interest in reform, and that creates a climate primed for meaningful steps back to the constitutional order. Confirming my assessment, Professor Gillian Metzger's recent defense of the administrative state in the Harvard Law Review, last fall, contained this note, quote, "Dismissing the present anti-administrative moment as a passing craze with little long-term impact would be a mistake." Thus, we all agree. But unlike Metzger, we should redouble our efforts to end rather than defend the administrative state. Now, the Trump administration's deregulatory efforts are quite helpful, but other than very good judicial nominations, they are more symptomatic of the broader deregulatory climate than an actual cause. And in fact, Trump might not have been elected if the public hasn't come to realize that regulatory bureaucracies are increasingly abusive and democratically unresponsive. Now, I think the administration's deregulatory efforts are still being tested. So like Philip, I'm going to turn instead to 4 targets of opportunity to reverse the gravest and most entrenched constitutional violations. I think the most significant one, and the one that I thought would be the hardest to reverse, is Congress's frequent subdelegation of its exclusive lawmaking power to agencies with vague and open-ended regulatory statutes. Congress unconstitutionally delegates huge swaths of its legislative power over different subject matters with the merest instruction that the relevant agency regulate, quote, in the public interest. Or, to quote OSHA's organic statute, that it issue workplace standards that are, quote, reasonably necessary or appropriate, end quote, to public health or worker safety. Well, what isn't? Now, the Supreme Court's minimal requirement for congressional delegations is that Congress provide an intelligible principle in statutes to guide the agency's rulemaking or lawmaking. That is woefully inadequate to prevent delegations of lawmaking power. But even this inadequate standard has been administered in an incredibly contrived manner for the past 81 years, until about 6 weeks ago. On March 5th, the Supreme Court granted cert in Gundy versus United States, the posture of which, and I'm only going to be very brief, the posture of which suggests that it may breathe a little bit of life back into the corpse of the non-delegation doctrine. The Supreme Court granted cert in that case solely to determine whether the Sex Offender Registration and Notification Act's delegation to the Attorney General to decide whether registration is required for those who commit crimes prior to the Act's passage. The Attorney General followed suit and Mr. Gundy was convicted. But there was no split in the circuits. In fact, all 11 circuits that had decided the SORNRA issue had allowed the delegation. In one case, over then Judge Gorsuch's dissent. And the reason the 11 circuits all agreed is because they had been beaten down relentlessly by the Supreme Court whenever they tried to police an extreme delegation. So they finally got it. All 11 circuits are in agreement. So it seems quite unlikely to me that now Justice Gorsuch and his fellow justices are really eager to affirm this unanimous 11th Circuit decision before the D.C. Circuit can issue a contrary ruling. Well, amicus briefs are due around June 1, depending on filing. Now, we in this room can suggest ways for the court to give some bite to the intelligible principle standard. And we should. But more importantly, we should also suggest to the court that it should consider a new standard that actually has a foundation in the Constitution. Now is the time to hone your arguments and send them to a receptive court. Regardless of how big a step the court might take in Gundy, if it takes one at all, a faithful president and Congress should enact some statutory reforms that are second best alternatives. For example, they should pass something like the REINS Act, which requires major rules to actually be enacted by Congress before they take effect. And that would restore much of the democratic accountability for at least major rules and prod the court to do more. So my second target of opportunity is to challenge agencies' frequent violation of both constitutional and statutory rules from rulemaking, regardless of the amount of delegation of lawmaking power they've been given. Now, my own colleagues at the Pacific Legal Foundation have launched 2 innovative waves of litigation in the past several months that we hope you all will support and then join or copy. Our first wave, PLF, filed 3 lawsuits in Minneapolis, Dallas, and D.C. challenging FDA's unconstitutional practice of delegating power to career bureaucrats to issue rules that bind the public. We specifically target FDA's deeming rule that threatens the livelihood of our clients and other vaping shop retailers. Peer-reviewed studies have suggested that up to 6 million lives can be saved as smokers switch to vaping if the industry isn't killed by this illegal rule. Now, we raise First Amendment claims in each of the cases, but our novel argument is that the Constitution requires that only principal officers appointed by the President and confirmed by the Senate can issue rules that govern our lives. Now, even if inferior officers whose offices are created by statute can issue binding rules, career employees may not. The same career employee who issued the illegal deeming rule, her name is Leslie Cooks, issued over 200 other FDA rules, almost all the major rules FDA issued in the 10-year period. A prior commissioner of FDA 20 years ago illegally delegated in writing the authority not just to sign rules, but to issue them. So FDA hasn't issued a constitutional rule in about 20 years. It's as if a Supreme Court justice authorized a law clerk to issue opinions in the law clerk's name and no one noticed for 20 years. It's a little bit unclear how long FDA has been doing this or whether other agencies are doing it, but we hope that you all will join us to stop the practice. Last week, my colleagues also launched a second wave of litigation, primarily to attack multiple agency failures to comply with the Congressional Review Act. One of those suits is on behalf of our ranching clients in Idaho who are threatened by the billion-dollar, thousands of job-killing sage grouse rules issued by the Department of Interior and Agriculture in 2015. Those rules were subject to court order and notice and comment rulemaking, but they were never delivered to Congress. When they are delivered to Congress pursuant to our suit, then Congress can use its expedited procedures to overrule them. Congress and the administration and the rest of you can do a lot more. The third target of opportunity, and my last two will be very brief, is to challenge numerous agency procedures, including those that Philip mentioned, that violate fundamental due process protections and short-circuit fair trials before an impartial judge and jury. Now, the ways in which the agency procedures violate due process and the Seventh Amendment are too numerous for me to list, but some of them may be discussed on Monday in the Supreme Court. The Supreme Court will hear argument in Ncaa versus SEC and hopefully issue its decision by June. While that case primarily involves the question of whether SEC's ALJs are officers and need to be appointed pursuant to the Appointments Clause, it raises larger issues about agency bias. One of the central issues in the brief is the disparate win rates that SEC gets between different tribunals. It wins over 90% of the time before its own ALJs. It won 219 cases in a row. Wins that are almost never reversed by the SEC and which then get deference in appellate courts. Unsurprisingly, its win ratio isn't quite as high in neutral federal courts. And guess where it's been shifting its filings of late? I'd be very surprised if these issues discussed in the brief are not at least discussed in the Supreme Court and raised in the opinion. My final target of opportunity is especially well known to this audience, and Jonathan focused on it, and that is the need to get the courts to stop violating their Article III duty to render independent rulings when they systematically delegate to agency interpretations of law, regulation, and claims of jurisdiction. Now, besides sanctioning APA and misconstruing APA requirements that add jurisdiction, they have invented various doctrines besides Chevron. Well, I got my time limit, 1 more minute. Happily, of course, there are many suits that are brought to raise this, and lower court judges are also getting into the act on and off the bench. Judge Kavanaugh's scholarly critique of deference doctrines that are triggered by ambiguity is a great start. And I want to mention one fun opinion by Judge Benson in Utah 2 weeks ago. In a win for the Free Speech Institute, Judge Benson not only ruled that an FEC regulation did not deserve Chevron deference, he then ordered that the regulation, quote, be stricken from the Code of Federal Regulations and enjoined the FEC from enforcing it. That's a nationwide injunction. Anyway, let me end on the note of personal privilege. as part of our stepped-up efforts to defend the structural limits of the Constitution. We are, as Dean noted, launching our Center for the Separation of Powers this very moment. And we hope you will join us for drinks and the closing to celebrate. The center will, as the judge noted, promote new strategies like the cases I mentioned to end the unconstitutional administrative state. We hope that Philip Hamburger and the Ncaa steals every one of our good ideas. We intend to steal every one of his. We intend to promote his. We intend to promote others. In doing so, of course, the center will also continue or contribute to the proper understanding of the Constitution's separation of powers. Thank you.
We now have a few minutes for questions. Anybody?
Come forward with a quick question. I guess this is for Mr. Eggleston and also for Professor Hamburger. In 1937, President Roosevelt sent a note asking what the agencies were doing because he was concerned about the effect of civil liberties and the encroachment of the administrative state. That note led to a summary of what administrative agencies were doing to try to protect it, which was obviously in their own best interest. And then the war interceded, and then that became the basis of the Administrative Procedure Act. So the APA was basically codifying what the practice had become, not something that Roosevelt actually intended it to be, which was a means of protecting individual liberties. So in that regard, if you were rewriting the APA today, what would it look like?
So I'm sorry, someone was coughing when you just got to the question part.
So
I heard everything up to the question.
my question is, if you're trying to protect individual liberties and constitutional liberties, and with whether it's a right-wing or a left-wing point of view, and you were rewriting the APA today, what would it look like?
So let me, I'm sort of answering that on the fly because I pretty much have not thought about that question. But I guess a few principles would make sense to me, which is I think, unlike other people up here, that there's a significant role for the administrative state. I think the FDA is good for me and my children. I like it that the Chesapeake is less polluted than it used to be. I like it that you can swim at the Potomac River and you couldn't before, and that's because of the Clean Water Act and also because of regulations that have been promulgated under the Clean Water Act. And so I could go on and on and on about what I think the benefits are sort of from the administrative state, and I think there's a lot of work has been done in connection with regulation always imposes costs, obviously, and I know that that's something people don't like, but it also can generate significant benefits in lots of these areas, significant benefits in terms of public health. I also, let me give you one other sort of preliminary answer, which is it's not my impression, which I think you would not, people on the panel would not agree with me, but it is not generally my impression that the courts have been shy at overturning regulations that they think are insufficient. In fact, I think the DC Circuit overturns even those kinds of determinations, how many points, parts per billion of benzene or whatever, with some regularity, and actually I would have said more than I thought. I do think that the so I guess what I think is that the process should be increasingly rigorous, but I guess and there are pieces of this and pieces of the arguments that I've heard. I think the argument about deferring to the agency on whether it has jurisdiction has always struck me as slightly odd. Although if you think about it, we do that with arbitrators, right? I mean, so when arbitrator gets, the courts generally say arbitrators get the opportunity in the first instance to determine whether they had jurisdiction. So it's not that alien. But I think there are some issues. I think this case, the Lucia case, is a fascinating case, although I think the SEC is now trying to correct it and sort of get around it. So I think there could be some changes. I know there's a statute, bipartisan statute pending. I think that is actually designed to just create massive litigation and keep there from ever being additional regulations. I think there's a subtext to that, and so I don't agree with, I think, Manchin, Heitkamp, and then I think there are a few Republicans. I forgot who the Republicans are, but I think they have a bill that's getting a little bit of attention. I'm kind of worried that has actually will have a negative effect and not a positive effect.
If I may just throw in my 2 cents on that. I have a very brief answer and a longer answer. For the brief answer, we actually had an Administrative Procedure Act before the one from the 1940s. We had one actually in the 1780s. It was called the Constitution. The slightly longer explanation. Look, think about what administrative law is. It's called administrative law to make it look law-like. Actually, it's more power. And it's an evasion. It's an evasion of the pathways the Constitution lays out for lawmaking and adjudication. And even when one sets up other formalities as a fallback in the APA, administrative power is just like water that floods over the banks. It evades those too and finds other pathways. The Lucia case actually is a beautiful illustration of this, and we devoted ourselves in our brief at the New Civil Liberties Alliance to this, not on the major constitutional arguments, but to say, look, there's no need to save the layered appointment level process at the SEC because these judges, these ALJs, non-judges, are not actually independent and never can be. Why not? You have all the formalities of administrative power. The APA would say, oh, look, you got an independent judge, he's fair, you get due process. But the reality is they're not allowed to hold against the lawfulness of a statute or regulation. They're already biased, regardless how personally superb they may be. What's more, according to administrative law, as you learn in the textbooks, they're all appointed by the rule of three, so the SEC can't choose its own judges, and those will be favorable. They can't choose them to be favorable to them. Well, in reality, as we pointed out in our brief, 3 out of the 5 ALJs at the SEC are actually lateral appointees from other agencies, including the Social Security Administration, where they have no concept of what it is to defend somebody's constitutional rights to their livelihood. So the agencies skew everything. This is just power. And no amount of APAs are going to prevent that. The problem with if we had administrative power that lived up to the APA and all the principles in the textbooks, we'd have a different conversation. It would be a much more plausible conversation. But that's not the nature of this power. And so I don't think a new EPA will do anything more than the old one.
We almost have time for one more question. Briefly, please.
Are we pretty much at the end of our democracy? In the city of Alexandria, the city council is using the police as thugs to prevent people or to intimidate people from standing up and speaking out at the city council meetings. And we have 3 examples that I won't go into right now. But where do people go? You can't go to your police. You go into the court. You're not allowed a camera. You're not allowed a computer. Our judges are doing everything in secrecy and with bias and using their discrimination in a way that marginalizes someone and is trying to make them look crazy instead of actually listening to the facts of the case. Are we at the end of our democracy?
Anyone? Todd?
Like Philip, I'm optimistic, and I wouldn't continue to work in public interest law if I wasn't. But I do think that there are ways to make our unconstitutional system constitutional without eliminating the regulatory agencies that Neil seems to like. Take, for example, the REINS Act type solution. I'm not necessarily endorsing that particular act. There are ways of having regulatory programs, but having democracy. And what I don't think can continue is the pretense that we have a separation of powers and the unconstitutional administrative state. One of those two has to go, but I'm optimistic about which way it will go.
Sure. The only thing I would add is that, the frustration you're talking about really captures the problem. That as more of our government shifts over to the fourth branch, to this insular cadre of bureaucrats, this frustration is going to grow. The thing that keeps this country together is this sense that people can have a voice in their government. But more and more decisions are being made by bureaucrats that are removed from that process. You don't know who you could go to petition for relief. And I don't mean to jump on Neil because I thought he had some great comments, but the point about the EPA is a good example of that. I happen to agree with the higher mileage requirements of the administration, but it doesn't matter. What I heard from Neil is saying, look, there was a big record before the Obama administration put in those limits, and I don't like the record that the Trump administration has put in the records. And for me, what was missing is this idea that this is a decision that should always have been decided by Congress, that this is a decision of tremendous importance, and to object that, well, you know what, we did a better job in making unilateral decisions than you're making unilateral decisions, leaves me rather cold.
Please join me in thanking the panel for a series of really excellent presentations.
Thank you, Judge. Appreciate everything.